Each party will have 15 minutes in which to argue your case. The appellant may retain up to 5 minutes for rebuttal if you would like to do that. If you are the appellant, you wish to retain that time, let me know when you come up with the podium. And keeping track of the clock and keep the class and passage of time. We are being visually and audibly recorded and posted online, so please try to remain behind the podium as much as possible. We hadn't read your briefs and we're going to proceed with you.
I would ask for 5 minutes for rebuttal. Donald Gallick on behalf of appellant James Burr. We come here today on a single assignment of error. However, within that assignment of error, there are many, many parts. As the court knows, this is a real estate contract dispute that's been going on since about, well, probably before 2015, but the case was initiated at 2015. Standard of review, of course, is abuse of discretion because the trial court ordered specific performance. However, I think nested within that abuse of discretion, there is some de novo review because we're getting into real law school stuff. We're talking about parole evidence. We're talking about when you can modify a contract through external communications, and usually you can't, but I know that appellee says in this circumstance you can. I think really you have a situation here of mutual mistake. The parties seem to not understand what the boundaries of the property was, how large the parcel was that was actually going to be sold, and to bring in a surveyor for this trial to say where the actual boundary should be. There were some conditioned precedents in the contract regarding variances and easements and things of that nature, but as the court knows from the briefs, it goes far beyond that. You find out there was an underground coal mine that no one knew about. I didn't know that was under the property. There's a leach field. We're not exactly sure exactly where the leach field is. You have all these other defects in the land. Appellee says, okay, you have to sell me more land. We have to expand the terms. My client says, well, I'm not doing that. I didn't agree to that. We didn't know about all these other defects in the land. Let's basically call the thing off. You have this resulting lawsuit for specific performance. There's various exhibits that are attached to the contract. The court got to hear, the trial court got to hear about some of the disputes in that because Mr. Burr says, hey, those exhibits, those weren't attached to the contract when I signed it. Actually, in the transcript, I believe at some point, appellee agrees they weren't attached to the contract. I want to say page 77. I think it's 77 that actually there was some agreement. Yeah, Klossner agreed that when he signed it there were no exhibits to the contract, but we're attaching them now, and they attached them to the contract that was put in the complaint that was filed. So what are the effects of those attachments if they weren't attached to the contract at the time of signing? I would say the parole evidence rule, and there's case law going back on that for centuries, you can't do that. They also attempt to introduce emails, and apparently the trial court considered emails. So you can see these emails after the contract show, we agreed to amend it, we changed the contract through the emails, we're going to change the terms, we're going to change the boundaries and how much land that you sell. I think that's a de novo review for this court because those are strictly legal questions of what are the limits of parole evidence, or more correctly, what are the rare exceptions when parole evidence can be used. I suggest in this situation it isn't. There's really no allegations of fraud going on either side, no matter what the dispute is between the parties. This is just confusion, it's just mistake. Had they known there was an underground coal mine, maybe this deal never would have been signed. Had they known that there were leach fields at issue or all these other defects in the land, or they didn't even know what the actual boundaries of the property were, maybe the whole agreement would have been voided, or actually void ab initio, because if you don't know what the subject matter of the contract is, how can there be a meeting of the minds to do the contract? Be no different than if you're selling a car and I thought it was a Ford, actually it was a Mercedes, so I didn't know that. If I'd known that, I hadn't sold it for that price. You have all of these exhibits. I can't remember, there's I think 35, 45 exhibits, there's depositions, arguing back and forth about what the actual subject matter of the contract is. When there's this much, in a way, the more this case is litigated, the more it proves that neither side really understood what bargain they were getting into at the time of the contract signing. It's really, even though there's all these factual complexities, it's really a question of, did the trial court abuse its discretion to order an equitable remedy of specific performance when there was all of this parole evidence that was trying to be used to amend the contract long after it had been signed. And after Appellee said, yeah, some of these exhibits weren't attached to the contract when he signed them, but they're still good exhibits, various maps and communications and boundaries and these kinds of things that were attached to the contract, and easements. There was this easement that went over the land that maybe they knew about, maybe they didn't. You look at all the parole evidence that's being used. So Ohio law, Ohio precedent doesn't permit that. Trial court should not have considered that, shouldn't have ordered specific performance, and really should have just chalked this up to mutual mistake. If there's no questions, I would ask to reserve the balance of my time.
Give me 5 minutes for rebuttal.
Morning, Your Honors. May it please the Court, my name is Doug Tershel. I'm here on behalf of Appellee David Klossner. This case takes us right back to our first year of law school. It's pretty simple. There was a contract, there was consideration. Courts are supposed to enforce contracts. First year law school property, all real estate is unique. Thus, the proper remedy for the enforcement of a contract for the purchase of and sale of real estate is specific performance. That's exactly what happened here. It's that simple. The contract had no question about what the real estate was. It didn't have a meets and bounds description at the time the contract was initially drafted. That's normal. That's what you hire surveyors for. The case law is very clear. You don't need a meets and bounds description at the time the contract is entered into. The law is it just needs to be reasonably specific. Here there was a drawing with a sketch attached to the contract that was no question. All you needed to do was have the surveyor come out and say, okay, give us a meets and bounds description of what that parcel is. The mention of the Exhibit A to the contract was not attached to the complaint. That was explained in the testimony in the court. Mr. Klossner testified that when the contract was sent to Mr. Burr, Exhibit A was attached. Mr. Burr signed the contract, said, yep, this is fine with me, faxed it back. The returned fax didn't include the Exhibit A. Later testimony in the trial said there's absolutely no question what Exhibit A was. Exhibit A to the contract was an exhibit at the trial. The court reviewed that. There was absolutely no question about that. Mr. Gallick likes to keep using the term parole evidence. He must have skipped that class in law school because there's no parole evidence involved in this case. There's a written contract that had some changes to it, amendments to the contract, if you will, that were all in writing and acknowledged by the parties. That's not parole evidence. There is no parole evidence involved in this. There are definitely a couple changes to the contract. They were submitted by the parties back and forth, confirmed in writing. Some of those writings were emails. That's the law allows that to be proper means by which you can accept a contract under the Ohio law. So the fact that they were agreed to in email doesn't make it parole evidence. It makes it a written amendment to a written contract. Standard of abuse of discretion is a very difficult one, as I'm sure this court's well aware. The decision of the judge was not arbitrary, it was not unreasonable, it was not unconscionable. If you tick through the elements required for specific performance, all of them were clearly met. The evidence was overwhelming. Number one, there's a valid contract. Number two, the contract is fair. Nobody's disputing that anybody was taking advantage of anybody here. Mr. Burr is an educated person. He has an advanced degree in pharmacy. He has done a number of business transactions. There was no unfair advantage, no special edge that anybody had in this matter. There's, as Mr. Gallick just admitted in his oral argument, there's no discussion, no argument of fraud or misrepresentation going on here. The contract's not unconscionable. It's not oppressive, and it clearly is capable of specific performance. The judge did that. It's a common, everyday, routine thing for a court to enforce a written contract. As you put on a court order saying, here's the legal description, it is hereby transferred from seller to buyer upon payment of the purchase price by the buyer. So all of those elements are met. The discussion of mutual mistake was not made in the trial court, first of all, but let's even assume we want to look at that. Not only was there no mutual mistake, there was no mistake. I don't know what the mistake was. The existence of the coal mine, for example. The evidence did demonstrate there was an abandoned coal mine underneath the property that Mr. Klossner initially was unaware of. My response to that is, so what? That's his problem, that's not the seller's problem. If the conditions precedent in the contract, for example, the contract said it was conditioned upon Mr. Klossner obtaining a zoning variance. He got the zoning variance. And a condition precedent for in requiring the buyer to be obligated to proceed, that's the buyer's problem, that's not the seller's problem. It's up to the buyer whether or not to even worry about those conditions being met. Here they were all met, so it's kind of a silly point to say there were conditions precedent and that that's some sort of a question here, because all the conditions precedent were met.
Was there an agreement on the leach field? There was a 15-foot easement that was.
Didn't need to be, but the answer is yes. The parties, again, that's another thing, it would be correct to say the parties weren't aware of the leach field issue, but again, that's another thing, that's the buyer's problem, that's not the seller's problem. The contract laid out the specifics of where the property would be and the driveway easement that would provide access to it to State Route 585. And the testimony from the environmental inspection person from the Wayne County Government Office said, yes, please don't drive over the leach field, or you can put a culvert under there to allow the leach field to flow through it. He said there were two different solutions, either one of which were satisfactory to the county environmental inspector, and the agreement as enforced by the court is consistent with either one of those, because the court order has the so-called temporary easement, which allows during construction when heavier trucks and so on might be going in, that you would drive around and not be even on the leach field, or the permanent driveway could be made in such a way that it doesn't impact the leach field. So,
And Mr. Burr agreed with one of those two, or both of those, or?
he agreed to the driveway easement, and he also agreed to the temporary easement. There was another thing called the workaround, you'll see, that there was some discussion about. But again, I would submit all of these are irrelevant, because this is an issue, it's conceivable. Let's take a worst case scenario that the leach field was such that nobody was allowed to drive over it, and thus Mr. Klossner bought a piece of land that maybe he couldn't use the way he wanted to. That's his problem. That's not the seller, that's not a right of the seller to say, ha, you can't buy this because you can't use it the way you thought you wanted to use it. Same thing with regard to the coal mine. Sure, the property can be used. There are areas where the coal mine is underground that would not be appropriate to put large amounts of weight on because of subsidence risk. But again, that's Mr. Klossner's problem. And there's
Well,
other,
as it was addressed in the original contract.
there's other spots on the land that don't have the coal mine under them, and it's not a problem. So it's an interesting little factoid that there are abandoned coal mines in various places in northeastern Wayne County. Other than that, it has no relevance to the outcome of the case. Unless the court has further questions, that everything else I think is well laid out in our brief. Thank you for your time.
Attorney Galloway, 5 minutes, sir.
Thank you. Appellee says that there was no mutual mistake argued. I mean, in addition to all these factual disputes that were argued incessantly, the 12th affirmative defense was there was no meeting of the minds. That's in Mr. Burr's answer. So you could say, well, no meeting of the minds, that's not mutual mistake. It's pretty close if you ask me. You know, Klossner says that he has a rough idea where the road is. That's in the transcript. They didn't know exactly where the road was going to be. The leach field changed it. At one point in the testimony, Mr. Burr says, apparently, according to Mr. Klossner, some of these costs are my burden. That would have been my burden, according to Mr. Klossner. That's on pages 38 and 39 of the transcript.
There was a reduction in price because of something along those lines.
That's true. I mean, we don't have precise numbers, I think. I don't know how much the road is going to be. I don't know if that's in the transcript. I don't know how much these other costs are going to be. I think Appley is correct. Some of the costs are going to fall onto his side, but however, they're talking in the trial court, some of these costs might fall onto Mr. Burr. So I mean, some of that was kind of unresolved. There were a lot of unresolved ideas, and I want to talk about these exhibits just real quickly. On page 71 and 77, it comes out that, I mean, it looks like in the transcript, these were not attached to the contract at the time of signing. However, it says in the transcript, they were provided to Mr. Burr and his attorney. Well, sure, through the discovery process, these exhibits were provided, but they weren't attached to the contract at the time of signing, at least from looking at 71, page 77 of the trial transcript. You know, the appellee says there's no parole evidence at work here, but I mean, look at the four corners rule. What's the contract? What says what's here on the page? That's not this case because, as he said, it was amended by email. Well, can you amend a contract through email without additional consideration? I mean, to the emails, is there a signature on the email? I mean, I don't know. I guess you could say in the age of e-commerce that we can make contracts all the time through electronic means, but this is a written document. Can we amend it through some emails going back and forth? Hey, we're going to have to change the burdens, the meets and bounds of the property. Hey, there's these conditioned proceedings that aren't met yet. There's a problem with the easement. I mean, can emails amend those, or does that violate the four corners rule or the parole evidence rule? You can say, you know, it's not oral, it's an email, but it's external. It's collateral communication that didn't exist at the time of the contract. It's after the contract was signed, and it's certainly not within the four corners of the written document. So I think it might be a little bit different if this was an agreement that was initiated through email or initiated through electronic means, but this was an old-fashioned, on-paper, ink contract, and you heard appellee say, well, it was just amended through the emails. Well, what's the case law on that? I don't know. I don't know if we fully briefed that issue, but that's an interesting thing that just arose here during the argument. Can you amend a written contract? There were some emails after the fact, and with some exhibits that weren't attached to the contract at the time. I don't know the answers to those questions, unfortunately. If there's no additional questions, I would just like to thank the court for its time.
Thank you so much for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to both sides as well as posted to our website and